Jack Smith's Deposition, Part 15. Cassidy Hutchinson. Welcome to Law and Society. What I'm doing now is going through Jack Smith's deposition in chunks, and I'm summarizing them for you. And the reason why I'm doing it is because it is important for every American to remember that Donald Trump incited an insurrection on January 6, 2021, and that he had a conspiracy to defraud the United States and the American people going on while he incited the insurrection and before and after the insurrection. It is important for us to remember this truth because Donald Trump and his flock continue to try to rewrite that history, and we simply cannot let that happen. So please remember to subscribe and like, and let's get started. I'm going to read the questions out first, and then the answers from Jack Smith. Question. The individual who worked for Mark Meadows by the name of Cassidy Hutchinson was a star witness for January 6 committee proceedings, and she made some real outlandish claims that, for example, one of them was that President Trump tried to control of the wheel of the Suburban that he was being driven in. Is that an allegation that you're familiar with? Smith. The circumstances regarding President Trump getting in the Secret Service vehicle after the ellipse speech. Yes, I am. Question. Did you evaluate that claim? Smith. We did. Ms. Hutchinson, regarding that particular claim, was a second or even third-hand witness. She had heard other people talk about that. So we went to and interviewed the people she talked to. And we also interviewed, if my recollection is correct, officers who were there, including the officer who was in the car. And that officer, if my recollection is correct, and I want to make sure I'm right about this, said that President Trump was very angry and wanted to go to the Capitol. But the version of the events that he explained was not the same as what Cassidy Hutchinson had heard from somebody secondhand. Question. Cassidy Hutchinson initially testified that no one informed President Trump before or during the rally that people didn't pass through the mags because they didn't want their weapons confiscated. During a subsequent interview, she sort of changed her tune a little bit and claimed that Deputy Chief of Staff of Operations Tony Ornato and other officials did inform President Trump that people standing outside the rally area did not want to go through the mags because they did not want their weapons confiscated. Did your office evaluate that claim? Smith, yes. And I think I discussed this earlier. We interviewed a number of people, and I think of this particular claim that there were a number of different perspectives about that. I believe it was Miss Hutchinson, Mr. Ornato. I believe Mr. Meadows, we spoke about this. And as I sit here now, I cannot recall what each of them said. I know each of them were seeing it from a different perspective. And they were that Mr. Trump at slightly different times. So as I sit here now, I can't recall that there were different perspectives on that question. Did your office consider whether you would call Cassidy Hutchinson as a witness at trial? Smith, we didn't make a final determination about any witnesses, but my recollection as I sit here now is that one of the issues is, one, there are so many witnesses that we could have called, and there was a need if we wanted to present a case in a digestible format where it wasn't just weeks and weeks and weeks of testimony. We had to slim it down. And my recollection for Ms. Hutchinson at least, one of the issues was a number of the things that she gave evidence on were secondhand hearsay. They were things that she had heard from other people. And as a result, that testimony may or may not be admissible. And it certainly wouldn't be as powerful as firsthand testimony. So I don't recall we made a final determination about that. But I remember in my mind that being a consideration, that some of the things she would offer testimony on would be hearsay. And we wanted to condense the case as much as possible for clear presentation. Question. If you were a defense attorney and you were given the assignment of cross-examining Ms. Hutchinson, Would you consider that assignment a very challenging one? Smith: well, if I were a defense attorney and Miss Hutchinson were a witness, the first thing I'd do was seek to preclude some of her testimony because it was hearsay. And I don't have the full range of her testimony in front of me right now, but I do remember that that was a decent part of it. And so that would have been my first gambit if I was a defense attorney. So that brings us to the end of the 15th episode that talks about Cassidy Hutchinson. Remember, we talked about Cassidy Hutchinson a lot during the January 6th committee hearings. Her testimony is her testimony under oath. However, in a court of law, the standard of rules of evidence is different, where hearsay of some being a second-hand witness is often not admitted as admissible in court when there is first-hand testimony and first-hand accounts of witnesses giving the same record. So it is normal for prosecutors and attorneys to consider hearsay evidence as being weaker than direct evidence. And that's what Jack Smith says in this episode, or in my episode in this section. With that said, thank you for listening, and I'll come back with episode 16 in just a little while. Remember to like, share, and subscribe, and I'll talk to you soon.